You trusted a doctor, a hospital, a medical team, and instead of getting better, you got hurt. If that happened to you, you may have a medical malpractice claim, and you deserve to know your options. Medical malpractice happens when a healthcare provider fails to give you the standard of care you were owed, and that failure causes you harm. That can look like a lot of different things. A doctor who dismissed your concerns, the wrong medication, a mistake during surgery, an error in the emergency room, unnecessary procedures, anesthesia gone very wrong, and in the most devastating cases, a wrongful death. If any of this sounds familiar, our team is ready to listen. Here's what we need to prove your case. First, that a medical professional or institution owed you a duty of care. Second, that they failed to meet that standard. And third, that their failure caused you real harm. Gathering that evidence is complex. It takes medical records, witness statements, and independent expert assessments. You can't possibly do all of that alone while you're recovering. We handle the case. You focus on healing. What can you recover in a medical malpractice case? We fight for compensation that covers everything you've lost, not just the obvious costs. That includes your medical bills, of course, emergency care, long-term treatment, physical therapy, psychological support. It also includes wages and your ability to return to work. It includes in-home care, mobility aids, and pain management. It also includes your pain and your suffering and your emotional distress, along with a reduction in your quality of life. If you lost a loved one due to medical negligence, we can also help your family pursue wrongful death claims, covering funeral expenses, lost future earnings, and much more. A few things you need to know right now. Do not accept a settlement offer before talking to us or another medical malpractice attorney. First offers always undervalue your losses, and accepting one can limit your right to pursue further legal action. In Washington, D.C., the statute of limitations for a medical malpractice case is 3 years, from the date of the malpractice or from when you discovered the harm. But you don't want to wait that long to start a claim. Filing a claim does not mean going to trial. Many cases resolve through settlement negotiations. Medical institutions have insurance companies working hard to minimize what they pay you. Those companies will twist your words, undervalue your losses, and pressure you to just move on. You don't have to face that alone. At Kitchell Injury Law, we have nearly 30 years of combined experience handling medical malpractice cases in Washington, D.C. We know how these institutions operate. I used to defend many of them, and I know how to hold them accountable. Visit kitchellaw.com to schedule your free consultation. The doctors in your life were supposed to take care of you. They didn't, so we will.